I'm John Hoelle, and I'm an attorney mediator here at Conscious Family Law and Mediation in Boulder. And this is my partner,
Peter Fabish, doing my first Facebook Live event ever. So thanks for joining us if you're there.
All right, so just a quick disclaimer. This talk is not meant to be legal advice. Any specific questions should be addressed to an attorney or a mediator with whom you have a formal relationship. So this is meant to give sort of a broad overview of some of the legal and procedural issues around divorce or legal separation in Colorado. And this video will be saved and accessible on our website for those of you who can't join us live today, but hopefully you can join us again in the future. All right, so with that, I'm going to turn it over to Peter, who's going to give an overview of the first main way that you can proceed with your legal separation or divorce.
Thank you, John. Welcome everybody out there who's listening. If you are listening, and it's because you're in a situation where you might be contemplating divorce or think that you might be facing divorce. We certainly are understand how grave that can feel and how hard that is. We see that all the time, and we're definitely with you on the challenge that represents. What we're here to tell you about today is hopefully to answer some questions that you might have, because a lot of people come into divorce with a lot of fear, and the fear is largely based on the fact that they don't know what's going to happen. And they've heard a lot of scary stories. So hopefully to give you some information that will reduce some of the fear that you might be feeling, and to let you know that there is a way through, and there's a way through that actually works well, that can set you up for success in the future, which a lot of people, I think, come into divorce with a lot of dread. That is just a terrible thing, and it's nothing but terrible. And it's just something to get through and hopefully rebuild on the other side, whereas it can actually be a process that sets you up for success in the future, you and your spouse and your kids. So that's what we're here to talk about. And with the way the divorce is done, just in broadly, there used to be really only one way to do it, which was traditional litigated divorce. And in that way of approaching divorce, usually people would both have lawyers, and then the lawyers would battle out the various issues with the clients in the background. More recently, there's been a huge movement toward people doing divorce without lawyers involved at all, and going through it either fighting with each other but without the help of lawyers in the courts, or just doing it in a more collaborative way together, sometimes with the help of a mediator at the end or for an hour or two to help them resolve a few issues, and getting it done that way. And there's a lot of self-help forums online about that. We'll talk about that a little bit more, that you can do that very thing. The third way that is, we feel here, we are on the leading edge of and developing it and making it more effective and user-friendly for clients, is mediated divorce, pro se mediated divorce. Pro se is the Latin. We probably need to think of a better term, thing to call this, but it's the Latin for not represented by counsel in law. And but in this case, it's a middle ground, and we'll talk a little bit more about this, but it's a middle ground between hiring two lawyers who go through a lot of conflict with you on the sidelines, and then in the end, after you paid them a lot of money, probably get you into a mediator and help you resolve the case. But in this case, in this mediated approach, we work with you from the very start as a neutral, and John's going to talk more about that in a few minutes, and we take you through the entire divorce. So that being the overview, I'm going to talk a little bit about conventional divorce, and just the traditional way that people do it. And this can be, again, I think the way I'll talk about it is just the sort of basic things that need to happen, and then maybe just mention a little bit about the difference between doing it with or without lawyers. In conventional divorce, you just, the parties don't one of the parties typically files a petition for divorce. Just in terms of background, in terms of whether you can do that in Colorado, at least one of you has to be domiciled in Colorado for more than 90 days. So 91 days would be the jurisdictional requirement, one of you having lived in Colorado if you're going to file in Colorado. And so at least 91 days has to have elapsed since the court obtained jurisdiction over the other party that you're filing on. So what you do to initially start it, you file a petition. There's a filing fee. It's $230 in Boulder County. The thing that to know about that it can dispel a lot of the things that people think about in terms of how divorces go is that in Colorado, like almost all states in the United States now, divorce is considered no fault. And what that means is you don't have to prove some bad behavior on the part of the other spouse in order to obtain a divorce. There's no way either spouse can stop a divorce from happening by saying that there wasn't some bad behavior. And in fact, for the most part, much bad behavior, although it's big in your life and understandably a big problem, and probably the reason why you're wanting a divorce, the court is mostly not concerned with it. The court is mostly going to be concerned with how should your property be divided, and how should your parenting plan with your kids be done. Now, bad behavior, of course, can come into play with parenting schedules and so forth, but we'll talk a little bit more about that. But for the most part, the court is not going to be interested in hearing about what a louse your partner has been over the last 10 years, whether or not it's true, unless it directly impacts parenting or their ability to parent. So typically once you filed the petition, it has to be served on the opposing party. Usually that's done through the sheriff's office. You just give it to them, they serve it. And then the person has to file a response, an answer within, 20 days, right?
21 days.
And they have to file they have to pay their own filing fee of $116. It's helpful if you both decide you want to divorce, you can file a co-petition together. That way you don't have, the other person doesn't have to file an answer and you save that $116. Once the petition is filed, the big thing that goes into place is the injunction. What it means is it sort of freezes everything in place. It doesn't mean you can't spend money for your normal expenses and all of that, but what it does mean is you can't go out and take a bunch of money out. You're not allowed to close credit cards, shut people out of healthcare coverage, that sort of thing. Everything sort of just gets frozen in place for the most part, until the divorce is final. You can't move. Neither party can move with the children, for example, and there's a 90-day waiting period until anything can actually officially occur. So from the time of filing until the time you could potentially be divorced, the minimum time is 90 days, although most times it takes longer than that. Once you've filed, you start hitting some deadlines for things you have to do, the most important of which is you have to exchange financial data. There's a whole set of financial data that you have to exchange. It's on a form that you can get from the court. It's Form 35.1 if you're taking notes, but it lists all of the things that you have to exchange with each other in order to be in compliance, in order to get a divorce, all the financial documents. It mostly has to do with bank account balances, retirement account balances. If you have a business, you have to provide all kinds of information about the business and the finances of the business and so forth. Then there's initial status conference. After that is done, at that time you set the hearing date. You make decisions about whether or not experts have to be appointed, like appraisers for a house is quite a common one. In the end, the three things that will need to get worked out, either through a hearing or through agreement, is a property division. It's called a separation agreement, and that will be or a separation order in which all of the property in your joint possession and separate property will be divided between you. First, the court will determine what is separate property. That's generally property that came into the marriage with one person and stayed separate. For marriages of long duration, there's rarely much of that. Then the court takes marital property and divides it between the two in an equitable fashion. Then the second thing the court determines, or you determine and agree to, is a parenting plan, which is the arrangements that you will have for co-parenting your children. How many nights will the children stay with each parent? How will you make decisions? Will they be joint or separate? On which particular items. There's actually an enormous amount of detail that can go into these agreements, much of which is difficult to know if you're not getting any professional help. But there are forms online for doing parenting plans. They're just not as detailed as some people ultimately find they need. Lastly, you determine maintenance. Basically, the spousal support. That would be if what used to be called alimony is now called maintenance. If one party is paying that to the other because they have a higher income and the other party needs it in order to meet their needs. This is normally a transitional payment that happens over some period of time that's related quite often to the length of the marriage. And the second is child support. That is determined through a formula based purely on the number of overnights and the incomes of the parents and certain expenses that they might be paying. And it's not something you can negotiate. Actually, it's something that's established by the courts, whereas maintenance can be negotiated. So that's pretty much the summary of the basics of a litigated traditional divorce. And again, as we mentioned, that can many people are doing that without lawyers at all these days, and there are a lot of court forms online for doing that. And if you have questions about how to find those, we'd be happy to answer those. We'll talk more about some of the reasons why you might want to or not want to do it that way. The other way is in traditional is with lawyers on both sides, and I think we'll have time to talk about the pros and cons of that as well as we move on to the talk. So, but now John is going to talk a little bit about another approach to divorce, which is mediation.
So thanks, Peter. If you're just joining us, you're welcome to ask questions through the comment section here on the live video page, or the event on our Facebook page also has some other, you can text us your questions or send them by email as well, and we'll address those a little bit later. What Peter just gave us was an overview of sort of what we could call the conventional divorce or legal separation process, whereby the two sides, whether with an attorney advice on either or both sides, or on each side, I should say, or without that advice, moves through the legal process. And the alternative to doing that is a more collaborative approach right from the beginning, where the parties are working more together. And the model that works well for a lot of people in that vein is hiring a mediator to assist the parties to work through that process collaboratively from the very beginning. That's generally hiring only one professional, especially if that attorney is also, if that mediator is also an attorney with family law experience. That person can guide the parties through the process, can give an overview of the procedures and the legal landscape, can bring their expertise to bear in terms of what the law requires, what judges might or might not do in the absence of agreement. What Peter was describing in the conventional process, if the parties can agree to everything, create a private agreement that then the court will ratify and approve and make a court order at the end of the process, and you'll have your legal divorce, which will set forth all the requirements going forward in terms of financial, property, and any children that are involved. In absence of agreement, the judge ultimately will decide and issue orders in your case. So the mediation process is designed to help you arrive at agreement so you don't have to go in front of the court, in front of that judge. So the mediator is a neutral third party. That means the mediator is not representing either party, is not giving legal advice to either party about what their, how to maximize their legal position, for example. But again, can help the parties understand what they do need to agree on, make sure you're hitting all the necessary components, and presenting your agreements in a way that's coherent and that the court will understand and be able to approve. But it's a voluntary process. It's your process. The mediator is helping you arrive at your final agreements. Can also help fill out the various paperwork. Peter mentioned some of the paperwork that's required, a lot of financial disclosure, and then ultimately your settlement agreements, which will include for certain a separation agreement if you agree on the financial and property pieces, and then a separate parenting plan if you have kids. That'll involve the legal agreements around the parenting schedule, parenting time, and legal decision making around the kids, and then child support will be flow from those agreements. The mediator is anything that's discussed in these mediation sessions is confidential under the law. The mediator can't be called as a witness or subpoenaed. The mediator's notes aren't admissible as evidence in the event that the parties do go in front of a judge. Nothing that's been discussed as part of that negotiation process, that settlement process, would be admissible in a court. So that allows the parties to feel free to really be creative and be vulnerable around what they can do, what they want to do with their agreements. So some of the, briefly, the benefits of a mediation process: you're only hiring potentially one professional to help guide you through the process, as opposed to having to hire a lawyer on each side, because a lawyer can only represent one party. So if legal guidance is needed, professional guidance is needed, then by each side, then they would each have to hire a professional. The goal of the process is to avoid litigation, as we call it. That's the adversarial process of taking your legal matter in front of the court. That said, in the mediation process, it's certainly, we advise all our clients coming here to get their final agreements reviewed by independent counsel. It's an important agreements that you're entering into with important legal ramifications, so you should get it reviewed by an attorney. But on the other hand, if your mediator is a family law attorney, you've probably gone over all the agreements in depth, and you ideally each party has understood everything very clearly, and so may not feel the need ultimately to get it reviewed by another third party. So that's a little bit of an overview of the mediation process. Again, if you have questions, please don't hesitate to let us know. But for now, let's move on, and Peter's going to talk a little bit about specifically for parents how to some things that can really help protect your kids from sort of the harm that can occur during a divorce process.
Yeah, thanks, John. And I'm gonna intermix that a little bit with just a comparative discussion of what the different ways to divorce. And just so you know, from a disclaimer point of view, here, John and I are both family lawyers, and we're the principals of conscious family law and mediation. We help people through divorce in all of the ways that have been just discussed. We represent people individually if they have to litigate. And we act as neutral mediators for people if they choose to mediate. So we see it all, and we do it all, and we understand that there are times where one of the other ways has to be done. There's as if one party is prepared to mediate, but the other one will not do so. There's only one choice, which is to litigate. So it has to be by agreement and so forth. But what you'll see is the two big differences between doing a mediated divorce and a litigated divorce, which is almost inherent in just the way that they're structured, is the level of conflict that tends to occur, and the cost. The cost is sort of obvious and easy to talk about. When you're litigating divorce with two lawyers, you can see that that's going to be just alone far more expensive than hiring a single mediator professional who, even if that person is a lawyer, you've got one as opposed to two. And litigation is designed to some degree to, each lawyer is trained to look for specific interests of their own client and fight for those. And quite often it gets approached in a way that you almost have to have conflict first before you can get to the table and talk about it. Like, both parties have to just sort of belt out their best position and why the other party's wrong and have a fight about it. And then almost inevitably, because very few cases actually go to hearing, I don't know how many people realize that, but usually it's at the steps of the hearing, at the courthouse steps, that people will finally go into a mediator and come to agreement in the end after all the fighting has been said and done. And typically, up to the couple is a minimum of $20,000 less wealthy than they were when they started, and that's if there's any kind of significant fighting going on, you're going up from the 20K, and you can easily get into the 50, 60, 100K range in those kinds of fights. So and so circling that around to children, with the protecting your kids and working with your kids, I'm going to talk about it in some general ways because it varies from age to age, of course, as parents, I'm sure, are aware. Each age your child is at is a different stage of development. I don't know how many people out there listening know that I have a background in psychology as well. I'm a master's in psychology and a bit a therapist. So some of this is coming from my own study in child development and psychology, and also just all of the learning I've done around how kids go through divorce. But the main things that are going to show up for kids, regardless of age, is the fact that there's this this disruption, this major break in the safety net of how they see the world. There was mom and dad, and now mom and dad are separating. So the two big things to think about around that are conflict and just reassurance and presence for the children. So in terms of conflict, what the research consistently shows is that kids do badly when their parents have a lot of conflict, and parents being able to model healthy conflict resolution is something that's very beneficial for kids. So oftentimes, if there's been a lot of conflict in the marriage, your separation ultimately, if it reduces that conflict, is going to be beneficial for the kids. And on balance, I think the studies show, and there's a lot of research into this because these are big questions. But if there's a high conflict marriage and the divorce results in less conflict, the kids, even despite the other balancing negatives of divorce, will end up on balance doing better. But then how you and your spouse handle conflict after the divorce is also crucial in that equation. So once you've gotten through the divorce, you have either the orders from the court or your agreements in place, being able to carry those out in a way that minimizes over conflict, so that you're able to work out your issues and they will inevitably be there. No matter how much you plan in your orders or agreements, there will be things that come up that you're kind of like, oh, we got to work this out between us. And if you're able to do that consistently well, that's extremely beneficial for kids. It sounds simple. It's not. Staying out of conflict is often difficult, as you've all seen. But it is hugely true. And the other piece of it for kids is assuring them that despite the fact, well, first let me just say that the other thing that the research shows very clearly is that unless there's issues like abuse or substance abuse or those kinds of things, physical abuse against parents or a child, if there's none of that and the parent is and both parents are fit parents, the children benefit enormously and And the opposite occurs if the opposite occurs by maintaining strong relationships with both parents post-divorce. So assuring the kids that mommy and daddy are no longer going to be together because of that they're not able to stay together in a way where they're able to be good to each other. But this does not mean that that either of our love for you is changing in any way. This is something that mommy and daddy are going to work out, but we will always, always be here for you. And refraining from disparaging the other parent in front of the kids. And that can be a tough one, I understand. We understand that here, because when you're looking at the other parent, you're thinking they're being totally unreasonable and doing stupid things and doing wrong things. It's sometimes hard to not say that in front of the kids. I can just tell you, it's very, very clear to the extent that you're doing it, it's not good for them. So if you're saying things like, well, if dad would just do this or that, then maybe things would be better, things like that, really hard for the kids to hear. It sets them up in an impossible conflict where they have to internally reconcile who they should align with. It creates a lot of feelings of unsafety, confusion, pain, leads to a lot of problems. So if there's any, several things you can do to most help your children, it's find a way to divorce that allows you to resolve your conflicts in the least destructive way possible, and to move forward in ways to come to agreements that you can buy into and work with and feel okay about, so that you're not always fighting over them. And maintaining and encouraging a strong relationship with the other parent after the divorce.
Mm-hmm. All right. Well, on that note, one more thing we wanted to talk about a little bit today that not a lot of people have encountered an additional level of support that they can get before, during, or after facing some of these family transitions. So one of the other things that we offer here at Conscious Family Law and Mediation is a form of mediation applied to helping people work through their disputes, in particular their non-legal disputes. So that often, we encounter people who come in, they're having some issues, they don't really know what they need to, what the future holds, what they need to do, and they're in some kind of crisis often. And so what we call couples mediation is an application of the conflict resolution technique of mediation, sort of alongside with some coaching, to help people work through and get clear about what they want to do for their future. And so the goal of that for a lot of people is to get aligned around a joint vision, get clear about what they're individual and what they're individually committed to and jointly committed to as a couple. And so this can be a complement to couples counseling, can be an alternative to couples counseling in some cases, and it works really well for a lot of people. It's very this mediation process is very concrete, goal-oriented, problem-solving, practical, very present and future tense. So a lot of the kind of common problems, common conflicts that people encounter when they've been in an intimate relationship for some period of time, these kinds of things, these problems kind of toxify an otherwise perfectly good relationship and mess with the natural affinity between two people. And so clearing this stuff away can sometimes be all that's needed to get people back to a place of nourishing stability, supportive relationship. So that's something that it's a bit of like I said, a newer approach of mediation that works for a lot of people. We offer it here at a discounted rate from what legal mediation would cost, and often people come in for a one session, maybe 2 or 3 hour session. We block out, we identify what the problem material is. We work up what we call a relationship agreement or a relationship contract. which again, this type of agreement is not meant to be a legally binding document, even though it will have the clarity and sort of precision of a legal document in terms of what are the agreements that the couple is prepared to enter into. And that can be something that we put windows of time on. We're going to try this for X period of time and come back and review it. It can continue to come to us for support in implementing these agreements. This form of working with people can expand into a legal mediation context. A lot of people have heard of prenuptial agreements, but you can also have a post-nuptial agreement, and something a lot of people haven't necessarily heard of. So you can enter into legally binding agreements in this special form called a post-nuptial marital agreement, specifically around certain financial kinds of issues. So that's something that can come out of this process as well. Anything that you wanted to add?
Can they put in the agreement that the other spouse has to stop being such a jerk? Can that be legally binding?
That would be something you could definitely put in there. The agreements are aspirational to a certain degree. I mean, we really focus on both handling the problem material, what the people are agreeing to in terms of how to speak to each other, how not to speak to each other, that kind of thing, as well as focusing on the positives and how we're going to increase the positive interaction. So really scheduling date nights is something that's so important, especially for parents of young kids. But handling the problem material in the relationship agreement means that the time you're spending together on your dates or just on your time at home, it's not going to be poisoned by these kind of reoccurring patterns of conflict, because that stuff is handled in the agreement. If it needs to be addressed further or readdressed, you come back in, you work on it with your mediator. You're not bashing at each other at home. So if this appeals to you, please feel free to reach out to us to get more information, or spend some time at our website, consciousfamilyfirm.com, where we talk about all these things. So we do offer what we call a clarity session. If you want to get more information about these different types of services that are available to you to help you get clarity moving forward around how to stay together in a more positive way, or how to transition your family through a legal separation or divorce, again through mediation, which we act as neutrals, or a more conventional route where we do also represent individuals in the divorce or legal separation process. I realize we didn't speak about legal separation versus divorce. So that's maybe something we can touch on briefly. Do you want to speak to that, or I can just give a quick explanation of the difference there. There is actually very little difference. A legal separation is just like a divorce in that you are getting a legal order, court order, dividing up your property and setting up any sorts of spousal support, things like that are needed. And if you have kids, you will also get a custody order with setting up the parenting time and the rights and obligations of the two parents. But you'll technically still be married. Historically, this was an option that was used for people who had a philosophical or religious reason that they didn't want to get a divorce. Also, it had an economic benefit in some cases if one spouse was a participant in an employer-sponsored health plan, which was a good plan and maybe affordable plan that the spouse could be on. That may or may not be available to have a legally separated spouse to continue to be covered under an employer-sponsored health plan. But in some cases, that seems to be available. Some of the bigger companies out there seem to be still offering legally separated spouses to be covered. So sometimes people opt for legal separation for that reason. One more thing to mention is that, and again, at our website, you can find some links and information about some other kind of creative arrangements people are entering into. Some people are opting to stay married, avoid some of the cost and potential disruption to kids of a conventional divorce, and are entering into really sort of creative arrangements. Some people are calling parenting marriages, where they're very much aligned as a team in terms of how to parent, and maybe are all going to live in the same house, or have maybe multiple houses, but the kids stay in one house. But maybe there's not a love and intimacy bond anymore, and so they're entering into something like a relationship agreement, like I was talking about before, that allows them to be very specific in how they're going to continue to function in that way for some period of time, maybe until the children are a little bit older, or even have maybe moved out of the house. So again, more information about that and some other kind of creative things people are doing at our website, consciousfamilyfirm.com.
I think that's it. Thank you very much for watching, and don't hesitate to call us if there's any other questions we can answer. As John mentioned, we have a very inexpensive clarity session that we do, which you can get an hour of time with us talking about some issues. It's not just so you know, it's not a legal consult, so we wouldn't be talking about all the law necessarily, but you can certainly find a lot about your options and wherever you're at. So,
thanks for watching, and we'll see you next time.
Thank you very much. So long.